Hello everyone, welcome back to my channel. Don't forget to like, comment, and subscribe. So today I will tell you about everything you need to know about filing a Jones Act lawsuit. Well, did you know that human errors cause between 70% to 96% of marine accidents? Well, every day maritime workers risk their lives. Sailors confront the risk of injuries and accident to their vessel's condition or the weather while at sea. While no company can control the weather, they can ensure the safety of their employees on board sea vessels. In addition, the Jones Act laws protect injured seamen, allowing them to get compensation and benefit. Often injuries and accidents occur suddenly out of nowhere, sometimes leaving terrible consequences in their wake. So, if you're a seaman and hurt while working on a ship, you may be entitled to file a Jones Act claim to recover damages. And then learn more about the Jones Act below. So, what is the Jones Act? The maritime law is known as the Jones Act. It is federal law that gives injured sailors who have been injured while at sea a form of compensation. In addition, they can sue their employer for a personal injury claim. Crew members are not eligible for workers' compensation benefits in either state or federal law. In contrast to other land-based employees who are, injured sailors are only entitled to compensation under the Jones Act and ordinary maritime law. Those who have been hurt or killed at sea due to carelessness or unseaworthiness may file a Jones Act action against their employer. And then, what does the Jones Act define as negligence? A sailor's employer is required by the Jones Act to provide a sufficiently safe working environment for the sailor. In addition, the employer shall take reasonable care to maintain and preserve the vessel on which the sailor works in a very fairly safe condition given the circumstances. According to the Jones Act, an employer may be held responsible for any and all kind of hazardous circumstances aboard a vessel. These include greasy or oily decks, and then failure of equipment, badly maintained machinery and equipment, and then proper supply of equipment to carry out your work, and then providing no training of the crew, and then unsafe working conditions, negligence on the part of other colleges. There are of course many other hazards that can happen. All this places a big burden on the employer to make sure the workplace is safe and secure. And then, do you need to hire a lawyer and what steps to make? In general, it is a step in the right direction to hire a Jones Act lawyer. They are experienced and know the ropes. Discuss this concern with your Jones Act attorney before proceeding with your claim to prevent inadvertently jeopardizing your chances of victory. Here are the steps to take when filing a Jones Act injury lawsuit. Avoid giving recorded statement first. You should know that providing a recorded statement is not mandated by law. Some vessels owner may put their own interests ahead of their employees by putting pressure on the injuries to provide such a statement. Sadly, sailors frequently comply believing they are helpful. Providing a recorded statement may actually harm your Jones Act claim. So, respectfully refuse and contact your lawyer before pursuing the matter. And then file an accident report. Similarly to the above, you are not required to fill out accident report immediately. However, there are benefits to filling out an accident report if you have been injured. A seller has 3 years to bring a claim to court. And then the next two things right in your Jones Act claim. You may do a few things if you have a Jones Act injury claims while on navigable waters to help your case. To help your case. The first, if you haven't already done so, report your injuries right away. And then the second, compile a list of witnesses' complete details. And then the third, avoid making any comments that implicate you in any kind of wrongdoing. And then the last, don't sign any papers until you have spoken with your Jones Act lawyer about the claim. It is of the utmost importance to take heed of the above steps. This step will ensure your Jones Act lawyer is in full control and can reach the best settlement for you or your family. Sail away to claim what's rightfully yours. Sailors may rest easy knowing that the Jones Act exists to protect them in case of workplace accident. So, if you were injured at sea due to your employer's carelessness, it is best to understand your right. Why not contact us for a free first consultation? Okay, are all maritime workers covered by the Jones Act? Well, all maritime employees are not protected by the Jones Act. 46 U.S.C. Section 30,104, which is a federal law that regulates the maritime trade between U.S. waters and port. While all maritime workers have a legal right, not all can access workers' compensation or other benefits through the Jones Act. To qualify to file a Jones Act claim, a maritime workers must be a seaman as defined by provisions. Within the law, those who cannot file a Jones Act claims may have other legal options. Filing for the Jones Act claim. Eligible seamen injured due to negligence of a Jones Act qualified vessel's owner, employer, or co-worker can file a legal claim to obtain compensation for certain damages. Here is the general process for making a Jones Act personal injury claim. Okay, the first, report your injury immediately to the captain, your employer, or a senior officer. Federal maritime law gives you 7 days from the date of the accident to report the injury, but don't wait that long. Don't try to stay on duty before reporting the accident because the vessel insurer may think you were not hurt enough to receive compensation. And then the second, seek medical assistance immediately. Save proof of any medications or diagnostic tests you take. Even if it is a minor injury, it is important to have a physician or medical personnel examine your injury so it is recorded and later can be used as medical proof. And then the third, when you report the injury, ensure that the captain enters it into the ship's log. Also, know that the captain or your employer is legally obligated to file a report using Form CG2692. And then the fourth, when your company provides an accident report, make sure to fill it out as soon as possible. Try to be as detailed and accurate as possible in the form, especially when filling out the section about who caused the injury. If you are confused about the at-fault party, seek legal representation immediately. And then the last, number 5, the captain will then send the form to the Human Resources HR department, which will forward it to the Workers' Compensation Office. If the vessel's insurance tries to make you give any written statement after receiving the CG 2692, or if you feel coerced into assigning any form that you don't want to, so consult a lawyer immediately to protect your right to compensation. Remember that insurance is like just another profit-driven company. Their goal is to minimize the value of your claim as much as possible. Okay, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe this channel. See you in the next video, and bye bye.